I am Dr. Geetha, Assistant Professor, Department of Commerce PG. Now I am going to share about the topic business law. Business law governs the world of commerce. We call these rules as business law or commercial law. The business law governs all dealing of businesses and the conduct of people associated with such businesses. Simply stated, law operates to regulate the actions of persons with respect to in one another and entire group of social estate. There are various branches there are various branches of law concerning specific aspects. For example, civil laws, criminal laws, administrative laws, constitutional laws, business laws, labor laws, etc. All business activities may basically be divided into two classes: commercial law and industrial law. So, mercantile laws, it relates to the contract of law. It also known as business law. It is only part of civil law. Business or mercantile law include law relating to contracts, sale of goods, negotiable instruments, partnership, companies, insurance, carriage of goods, insolvency, consumer protection, etc. Next one is contract. Indian Contract Act 1872. According to Section 2H, a contract is an agreement enforceable by law. It is clear from this definition that a contract must fulfill two conditions. One is there must be an agreement. Second one is such an agreement must be enforceable in a court of law. So contract equal to agreement plus legal obligation plus enforceability. All contracts are agreements, but all agreements are not a contract. Next is agreement. What is agreement? Yeah, definition of agreement. An agreement is defined in section 2E as every promise or every set of promises forming a consideration for each other. Agreement is equal to offer plus acceptance. So an agreement involves proposal or offer by any party, and acceptance of the same by the party. Nature of contract. Next one is Indian Contract Act defines contract as an agreement enforceable by law. First, there must be an agreement, and that agreement must be enforceable by law. Contract requires first one is two parties is needed. For a valid contract, there must be two parties. Same party cannot make contract on both the sides. For example, if A promises to sell his house to B for 1 lakh rupees, then A is known as promiser as he is selling his house, and B is known as promisee as B promises to pay 1 lakh rupees to A. Next is an agreement. For a contract, there must be an agreement, a proposal from one side of the party to do a particular thing, and acceptance by other party on the same thing. Next, obligation. So, obligation means legal duty to do something, and an agreement which contains only social or domestic agreements are not contracts. All agreements are not contracts, but all contracts are agreements. For a contract, there must be an agreement. Without agreement, there cannot be a contract. It means all contracts are agreement, while for an agreement to become contract must rise to a legal obligation. If the contract is not capable of any duty which is enforceable by law, so it is not contract. So agreement of religious, social nature are not contracts. For example, if A promise to lunch together, work together, or not creating any duty enforceable by law. So these are not contracts. At the same time, if a promise to sell his car to B for 50,000 rupees and B accepted the proposal, so it is a legal agreement because it creates legal obligation between the parties. Next, we have to see essential of a valid contract. What are the essential means? A valid offer and acceptance, intention to create legal relationship, lawful consideration, capacity of parties, free consent, legality of object, agreement not declared void, terms of the agreement must be void, possibility of performance, and the last thing is legal formalities. So first one is we have to let us now discuss these various essential elements. So a valid offer and acceptance. So a contract is a valid contract only when there exists a valid offer and its valid acceptance. So the term of the offer must be precise and clear. So the acceptance of the offer must be absolute and unconditional. The acceptance must be given in accordance with the prescribed mode and before the offer lapses. So next one is intention to create legal relationship. The intention of the parties to a valid contract must be to create legal relationship between them. So that is the intention to create legal relationship between the both the parties. Next one is lawful conservation. So for a contract to be valid, the agreement between the parties must be backed by consideration. So what is consideration? That is something in return. So both the parties to the agreement must give and get something written. That is consideration. So we can getting something in return from the party, one party to another. So for example, B agrees to sell his bike to Q for rupees 25,000. Q's promise to pay is the consideration for B's promise to sell the bike, and B's promise to sell is the consideration for Q's promise to pay. So consideration that must be real and lawful. It need not be adequate. It need not necessarily be in cash or kind. So it may be promise to do or not to do something. So next one is capacity of parties. That must be competent to contract. That is capable of entering into a valid contract. A person is capable of entering into a valid contract if he has attained at the age of majority, is of unsound mind. Unsound mind person is not eligible for enter into a contract. So if so sound mind and is not disqualified from contracting by any law with to which he is subject. For example, A lends for rupees 1,000 to B. At the time A is minor. At the time B is minor. A cannot take legal action against B because of B is a minor, not a major. So legal action against, that means A cannot take legal action against B for repayment, as an agreement with the minor is void. So next one is free consent. Consent means willingness. So the consent of the parties to a valid contract must come freely. it must not be obtained force or by must not be force. And also a contract in which the consent of the party is not free becomes voidable contract. So it can be avoided by him with reasonable time. So that means it is a willingness. Next one is legality of object. So the object of the agreement must not be illegal. So it should be a legal one, immoral or opposed to public policy. So that is a legality of object. For example, A enters into a contract with B to supply certain prohibited goods. Such an agreement is void, but as it is object is illegal because of prohibited goods. M lets out his house knowingly to a prostitute who has promised a big amount as monthly rent, but such an agreement is illegal as its object is against the morals of the society. So these cases are comes under legality of the object. This is an best example. So agreement or not, next one is agreement not declared void. So the agreement between the parties must not have been declared void expressly by any law in force in the court. For example, under the Indian Contract Act, an agreement restraint of marriage or an agreement in restraint of trade is void. So next one is terms of the agreement must be certain. The terms of the agreement must be clear, prescribed and certain. If the terms are vague, the agreement cannot be enforced. So next one is possibility of performance. What is undertaken by the parties to an agreement must be such that can be performed. And also an agreement to do an impossible act cannot be enforced. For example, A agrees to prove the two parallel lines can meet if B pays him rupees 10,000. Such an agreement is incapable of being carried out and is therefore void. The next example is G agrees to turn iron to gold if H pays him rupees 1 lakh. An agreement such as this cannot be enforced in a court of law. The last one is legal formalities. For a contract to be enforced, that means enforceable in court of law, it must comply with the necessary legal formalities as to writing, stamp duty, registration, certification, witness, etc. So the contract will be a valid contract only when all the essential elements mentioned the above are present in it. So these are the essentials of a valid contract. So next one is we have to see the classification of contract. So the classification divided into three categories according to enforceability, according to formation, according to performance. So under according to enforceability, classified into 6 categories: void agreement, void contract, voidable contract, unlawful agreement, illegal agreement, unenforceable contract. So according to formation, express contract, implied contract, quasi contract. So according to performance, under executed contract, executory contract, partly executed contract. These are the basis for classification of contract. So let us we discuss these now. So based on enforceability, the contract classified as follows. So first one is void contract. So according to section 2G, an agreement not enforceable by law is said to be void. Agreement not enforceable by law is said to be void. So the void agreement is void. That means ab initio. That is a Latin word. The meaning is from the beginning. For example, an agreement with the minor. Minor means a person whose age is below 18 years. So an agreement with the person of unsound mind, not a sound mind, it's an unsound mind. An agreement without consideration subject to certain exceptions. So these cases are void agreement. Next, void contract. That means a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. For example, P agrees to marry Q's daughter, but before marriage, P dies. A valid contract thus has become void. Uh, Another an example is P agrees to sell his cycle to Q and receives from him rupees 100 as advance. Before the sale is affected, the cycle is lost. The contract becomes void. P shall return the advance money. So that is a void contract. Next one is voidable. So voidable contract means an agreement which is enforceable by law at the option of one or more of the parties thereto. A contract is voidable contract when the consent or willingness. Consent of the parties means willingness of one party has been obtained by the other by such unfair means, threatening, undue influence, fraud, etc. So, what's the difference between void contract and voidable contract? So, void contract cannot be enforced by either party. Voidable contract is valid until it is avoided by the affected party. Void contract was valid when it was made. Due to subsequent happiness, it has become void. That is unenforceable. Voidable means a voidable contract is valid until it is avoided or resigned by the affected party. Such a party, however, has to avoid it within a reasonable time. So next is unlawful agreement. So that is it is one that is not approved by law. Unlawful means not approved by law. One some ground of public policy. Next one, illegal agreement. That is involve the commission of a crime, violent basic public policy, or immoral in nature. These are they call it as illegal agreements. For example, A employs B to kill C and promises B a sum of rupees 10,000 for doing the job. If B kills C, he cannot claim payment from A. And if A has already paid the amount and B does not kill C, A cannot recover the amount. So it is an illegal agreement, just opposite to the public policy. So next one is unenforceable contract. Under a classification of according to enforceability, the last point is unenforceable contract. That means sometimes a contract may become unenforceable owing to certain technical defects in it. For example, where the party to a written contract has not given his or her signature. So instead of some more person put signature, that is unenforceable contract. Absence of certification by notary public or some other authority, such certification is necessary. So these are all the best examples. So next, second classification is according to uh, formation. So based on these mode of formation, the contract may be classified as follows. The first one is express contract. It is the one that is entered into by the parties by words. So express, only we have to express the contract by words or spoken or written. Usually it will be in a written form. For example, X offers to sell his house to Y for rupees 15 lakhs. Here Y accepts X offer and they both sign the sale agreement prepared on a stamp paper on the appropriate value and is duly signed with the witness. So the results in a contract between X and Y. So only we have to express whether the by words or spoken or written form. Next one is implied contract. That is, it does not arise out of express promise by the parties, but is inferred from their acts or from their circumstance of a particular cases. Example, A offered by a cinema theatre and its acceptance by movie. So is always the result of an implied contract. The last one of performance classification of performance is quasi contract. It is not actually entered into by the parties but something imposed on a party by law. So it is based on the principle that a person shall not be allowed to enjoy certain benefits unreasonably at the cost of another. So next classification is classification according to performance. So based on that we have to classified something: executed contract, executory contract, partially executed contract. So executed contract means the contract is said to be executed. That means when both the parties to fulfill their respective obligations, then only the contract is called executed contract. For example, X, a carpenter, agrees to make a table for Y for a sum of rupees 2000. The contract becomes executed the moment X makes the table and Y pays the agreed sum. So they have to make the table. X make the table. Y pays the money to get back the tables. That is called executed contract. Next one is executory contract. An executory contract, that means it is one in which both the parties are yet to fulfill their respective obligations. For example, L agrees to sell his watch to M for rupees 500. The contract is an executory contract until L hand over the watch to M and M pays the agreed amount. So last one is partly executed contract. So it is a contract which one party has already fulfilled his obligation. So partly executed means one person already fulfilled his obligation and other is yet to fulfill his obligation. So for example, a departmental store supplies goods to a customer who pays by credit card. Thus, although The departmental store has fulfilled its obligation. The customer's obligation is fulfilled only upon the realization of his payment. So these are all the classification of contract. The contract classified into three cadres. First one is according to enforceability, according to formation, according to performance. Thank you all.